Good morning, and welcome to Our Neutral Voices Presents A Financial Pillar. I'm Ryan Leopard, and joining me on the set today, once again, my friends from DR Financial, Chris Hanna.
Good morning.
Mark Ellington.
Good morning, Ryan.
From Our Neutral Voices, welcome back, Mildred Lopez.
Good morning.
Good to have you back.
Thank you. It's good to be back and good to be seen.
Awesome. And then joining us on the set also, special guest, attorney Kyle Gough. Kyle, welcome.
Thank you. Appreciate it.
Thank you. Kyle, we wanted you to come in and talk with us a little bit today. Kyle specializes in wills, trusts, and estate planning, so we're going to kind of talk about the importance of that to our financial stability. Okay. So I just want to give you the floor first, talk to our listeners out there, just tell them a little bit about yourself.
Sure, absolutely. So again, my name is Kyle Gough. I'm an attorney practicing in Fort Wayne, Indiana. Started my own practice in 2019, right before the pandemic. Great timing.
Perfect.
I had about 5 months build up before the pandemic started. That was lots of fun. But I've done estate planning since I started practicing in 2016. I also do business law, and oftentimes the two intersect. So I also work in that space as well. I've done a lot of different estates from all different sizes, anything from someone who's doing their last will with almost nothing, all the way to someone who has $20 to $30 million estates and everything in between.
Gotcha. Good, good. You know how many times I've had a conversation just this week on people who've started a business after or during the pandemic.
Yeah, it's amazing.
It's probably the third or fourth time this week I've talked to somebody that's actually done that. That's a true story. But interesting. Well,
Unlike most of your stories, it's a true story. Unlike most.
You gotta say it's a true story, right? Questions your other stories.
It does.
Yes,
it does.
Yeah.
That's a good point.
Thanks for pointing that out, Mark. Thank you. But Kyle, yeah, thank you again for joining us today. So I want to kind of jump in, to the importance of having a will, trust, or estates and understanding that, because it's a conversation that most of us don't want to have.
Sure.
Right? But it's inevitably one that we have to have because there's one certainty in life, and that is we're all going to pass away. We just don't know when that's going to happen.
You know, that's a great point, Ryan. And there's no better way to illustrate this than to talk about some of the different celebrities that have gone through this experience without having a will. The one I like to talk about first is Jimi Hendrix. So Jimi Hendrix passed away in 1970, and the battle for his estate lasted more than 30 years, and because he did not have an estate plan. And so Pablo Picasso had a very similar experience. Howard Hughes, similar experience. But it's not just celebrities. There are also people who are not celebrities who have the same experience. It may take a long time. Maybe they're not fighting over as much money, but when you mix family and money, scary things can happen. So it's very important to have that estate plan in place to make sure that there's no discrepancies, and so that the estate can wrap up very quickly.
Mm-hmm. Being in the banking industry, I can speak for that because I saw that numerous times. Where you got a tight-knit family, and all of a sudden money comes into play because somebody passes away, and all of a sudden, fighting starts.
Well, that's just it, right? And it's not even that. It's one of the challenges of estate planning is oftentimes you don't know that the person that is helping you to create your estate plan knows what they're talking about, because you don't find out until that person passes away. And then they passed away, and they're like, well, now the kids have to deal with it. And so there's not a lot of accountability in that space as well. So you've got to make sure not only are you talking to someone who is quote unquote an estate planner, but actually someone who knows what they're talking about.
Yeah.
So I have a question.
Sure.
I want to know, do you need to have an estate attorney with a will? Or in other words, do you need both? And what's the difference?
So an estate attorney with a will,
do you need an estate attorney if you have a will?
If you have a will. Okay.
Can you do one or the other, or do you need both? Because I know wills and estate planning are kind of, there's a difference.
Sure, absolutely. So there are some people who don't have an estate plan or don't have a will or a trust or other planning document, and when they pass away, it's something called intestate, and there's some default rules that sort of kick in, and each state has their own different rules for what those look like. So Indiana has intestate rules, and there are defined. These rules are defined by Indiana code, and they'll specifically say this is what the how this estate plan is going to transact. But then you can also have someone who has an estate plan or has a will or some other document in place. If that document was not drafted by an attorney, then it may not be valid. And it's not, like I said, it's not just any attorney. It really should be someone who holds themselves out as an estate planning attorney to make sure that the qualifications, that the document was executed properly, that the language in there actually contemplates what's going to happen. And I'll give you a great example. So, there's one that I'm working on right now. It has a farm, and there's 3 children, and the father passed away with 3 children, and there's 150 acres, and so they're splitting it between the 3 kids, but it doesn't specifically say who gets the barns, and so the children are all fighting over who gets the barns. And if the estate planning attorney had just said children A gets this barn, children B gets this barn, and child 3 gets this barn, then it would have solved the entire thing. But now they're spending tens of thousands of dollars to argue about who gets which barn. And that happens all the time. So it's not just about having the document, it's also about having one that is drafted properly and contemplates what's going to happen after. And that's why it's called estate planning.
Yeah. And this is a good point, part where I want to start, like, kind of explaining each one: a will,
Sure.
a trust, and a estate, and what they do for you.
Sure,
right?
absolutely.
So I think a lot of people, in my experience, think the will is everything, right? But yet that doesn't necessarily mean anything to a bank when it comes to your money. So
That's
can
a
you
great
kind of
point.
start with a will and what that does for you, and
Sure.
the importance of that?
Yeah, absolutely. So the will, like I talked about before, if someone passes away without a will, then they have these default rules that are intestate. If you pass away with a will, it's called testate, and the will overrides the default rules. So if there are specific things that you want to do that you don't want the state to have to decide how this is going to be divided, then you should really have a will document in place that says, hey, this is what I want it to do. So if you're married, you have a spouse, then you want some certain amount to your spouse, certain amount to your kids, or a certain amount to a charity. You can do all of those things. It adds additional flexibility beyond the default rules, but it has to be executed properly in order for it to be in place. And that's a whole nother topic for a whole nother day. But that will document, formerly called the last will and testament, is a really important document because it really clarifies beyond those default rules what that person wants. And then there's another document that's often used in estate planning. It's called a trust. And a trust was formerly, it's primarily used to try to avoid the probate process. But you have to have certain elements for a trust. You have to have a grantor, someone who's creating the trust. You have to have a trustee, which is the person who's managing the trust. And you have to have a beneficiary, who's the person who's benefiting from the trust. And as long as those 3 things aren't all the same person, then it's okay. You also have to have something in the trust. Otherwise, there's nothing for the trust to hold. If it doesn't have properties, not properly formed, and it fails. So that document adds additional flexibility beyond what you can do with a will, but it also can be used to avoid the probate process, which means avoiding going to court. Now, that's not always the truth, because sometimes you can also put trusts inside wills, and some trusts aren't actually used with some trusts aren't used specifically for estate planning purposes, so it gets a little complicated. However, oftentimes when you're doing a trust to kind of replace the last will and testament, you'll still have a will. It's just functioning differently. Usually it's called a pour-over will, and what it does is it takes whatever stuff you have left that's not part of your trust, and when you pass away, and it puts it in your trust. So that way it makes sure that all of your assets eventually will end up in that trust after you pass away.
Okay. And then to kind of help our listeners understand a little bit from a banking standpoint what that means to them, and maybe this relates to you guys as well, is that with a will, somebody comes into the bank and they said, my father passed away, here's his will, he's got money with you, I want to close account. The will means nothing to the bank. Essentially, and correct me if I'm wrong on any of this information, but all a will does is basically say, if you pass away, and you don't have an estate set up, it tells the attorney what your wishes were when they go to create the estate.
Correct.
Right? And go to court with this stuff.
That's right.
But a bank's still going to need the estate paperwork. That means attorney, courts, all that stuff to get involved to create the estate. Then you go back to the bank with the estate paperwork that basically directs the bank on what they should do with the assets.
I
Right?
think we got a question behind you too.
I do, but I thought if in the bank industry, if you already have a beneficiary on your account, you don't need that. Is what I understood.
Well, that is correct. But that's
Okay.
something different. That's why everyone, in my opinion, should have beneficiaries listed on their bank accounts. But
Well, I'm just talking about for listeners who are low income, who may not have estates, who may not have tangible items to create a will or have an estate attorney, but they do have a savings and checking account. So that listing them as the beneficiary on the bank side,
that trumps everything.
correct?
Yes.
Is that correct?
So that's a good point.
Okay.
And that's why I recommend to everybody. It is absolutely amazing how many people do not have beneficiaries listed at all. Whether it's because they didn't think about it, whether it's because their banking institution never brought it up and asked them about it. Because anytime I bring it up and ask, they're all like, oh yeah, that's a good idea, I should do that. You should have beneficiaries listed on your bank accounts, as well as I'm sure your investment accounts with you gentlemen as well, that basically it trumps everything. If you pass away, you've already designated to that financial institution what you want done with those funds, who it should go to and what percentage you want to go to them from. And then therefore you don't need to have an estate necessarily for those assets.
Correct.
Right? If there's other stuff out there, you may need that for it. But essentially just differentiating between a will, a trust, and estate. A will basically only directs the attorney of what your wishes were when they go to create your estate.
Yeah,
right?
so a great way to illustrate this concept is to think about the probatable assets, the things that go through the court system when you pass away and you have a last will and testament. The probatable assets are the only things that you have when you pass away. So if something is not in your name, if something is maybe you've given it away, maybe there's some other operation of contract that says, hey, when I pass away, this thing happens automatically, and that operation of contract or operation of law will actually trump the probatable asset process. So the beneficiary is a great example of that, because there's a contract that says this person is going, or this entity is going to be the beneficiary of this account, and you see this a lot in life. In life insurance, you'll see this in financial accounts, you'll see this in your bank accounts, where you actually get to designate a beneficiary. In some instances, you will actually designate your estate as the beneficiary, and that does happen on occasion. I don't recommend doing that unless and until you've talked to an attorney about what you want to do with that. But it is a really good process, a good way to do that if you're trying to get all of your money into the probatable asset category. So it's a great point.
Yeah. So we got wills, trusts. We mentioned trusts on there. So trust you can think of as like its own entity.
That's right.
It's kind of like a business. When you're talking about the grantor, the beneficiary, and then what was the other one? Grantee?
So the trustee.
Trustee. Okay. Now the grantor and the trustee can be the same person.
Yes, they can.
Right? So basically you're creating a trust for yourself that you're the trustee on, so you're the one that operates the account while you're living. If you pass, you basically already set up this entity that the paperwork says who your successor trustee is, or should say that.
Should.
Therefore, you pass away, you come into somebody like myself at the bank, and you present the death certificate, and then in turn with the trust that's already established, it tells us who we should add as a trustee to continue on.
That's correct.
With that stuff.
Yeah,
okay?
that's correct.
One of the biggest things from my side of things, errors that I see, is somebody will set up a trust, but yet they will never convert their bank accounts to a trust, right, under the name. They still
Yes,
keep it under
right.
their personal name. They think, oh, well, I went to Kyle and I created a trust, so everything should be under there. No, you still have to go open a new bank account under the trust name, the trust tax identification number with you as the trustee, or whatever the case may be, close your personal account and transfer the assets to the trust account. If you don't do that, it's still not covered under the trust, right?
That's
There's
exactly
more
right.
work to do after you pass when this mistake is caught.
That's
correct?
right. That's 100% right. And if you think about it, like any other entity, it holds property, it holds money, or whatever you want to put into this trust, but you actually have to put it in. You have to have documentation that says that the trust owns these things. And if you don't do that, then you're going to run into the exact problems that you're talking about.
Yeah, you run into, you never had any beneficiaries to your checking account. When you were alive, you thought everything was good because you had a trust created by Kyle, and then all of a sudden, your heirs, right? They go into the bank saying, I need to close this, do this, and wait, it's not set up. Now it's more attorney costs, things like that to get things taken care of.
So I have a question.
Yes.
So we're talking about assets and we're talking about the monies that we may have. Now, in general, we don't inherit debt. So with estate planning, do you include any debt? Because I know there's some debt, so for instance, if I die, my children in general won't inherit my debt, like my credit card bills, my personal loans, any medical bills. Those will be absorbed, correct? So what happens to the debt when someone dies?
Yeah, that's a great question. So oftentimes the language that we include in our estate plans talk about paying legally enforceable debts of the estate. We will direct them, the estate, to pay any last medical bills or funeral planning or things like that. And then also there's usually tax considerations that you have to think about because the way that our tax system works, everybody pays a year late. So usually there's one more, there can be one more tax filing that has to be done. So you'll also need to empower the personal representative to be able to file taxes, and that documentation is usually included in the last will and testament as well. It's generally true that those debts aren't going to be enforceable amongst the heirs. There are some exceptions if those people are personally guaranteed. There's some really obscure code in Indiana that talks about the ability for a spouse to have like a dependent spouse to have those debts enforced, to have their debts enforced by the person who's supporting them. It hardly ever happens, but it is possible. So it's I can't say like 100% true that no debt ever goes to the heirs, but there are some instances, but generally it's.
What about like the mortgage on the house? So
Typically, that's what I was going to say.
My parents passed away, or my mom's already passed away. My dad then second. There's still $100,000
Something that has collateral.
Yeah,
It's not a type of loan, a secured loan, those typically are. But when it comes to like a credit card, something like that, at least that's my experience having worked for the bank I worked at, is usually they just forgave the debt.
That's 100% true. Yeah. So
They couldn't file against the estate if they wanted?
they can. Yes,
That's why I didn't know if it was something they just choose to do that, or if legally they can't. I don't know.
They can. You can file against the state for debts, and they have a certain period of time to do that as well. So first, the secured debts are things that have collateral, and those are going to be enforceable to the extent where they can take back the collateral.
Yep.
And then he's correct. You can also debtors can also file against the estate, or they can actually open an estate if there isn't one that there's one that hasn't been opened yet. Oftentimes for creditors, that is a hey, do we actually think we're going to be paid? This is going to be worth it. So if the debt's low, or if they don't think that the estate has any resources, then they're less likely to want to open an estate against the debtor. So there are instances where they can try to collect against the estate. They're not necessarily going to be collecting against the beneficiaries themselves, but it is possible for them to, in some instances, attach, depending on what type of debt it is.
So are you saying that the credit cards that my family has should only be opened in my wife's name? Generally? That way if she
Yes, Chris.
This me, then I don't have to pay her credit card debt.
Yeah, so they
See his mind working right now.
yeah. Yeah, so again, they probably be they could potentially be enforceable against the estate.
And they said that was my experience having worked for one of the largest banks in the country, large credit card providers, is typically they would, the way that they would respond to that is like, to an heir is, hey, you're not legally obligated to take care of this debt, but we would be willing to accept a payment if you wish to do so. Right?
And there are
I've had people wish to do so.
Right. And there are some, and this is actually brings up a great point, because there are some trust documentations. One particular is a spendthrift trust, but it doesn't focus on the decedents, the person who's passed away. It doesn't focus on their debt. It actually looks at the beneficiary's debt. And in a spendthrift trust, what you can do is you can actually say, hey, I don't want the beneficiary's creditors to be able to attach liens against this trust. So if you have someone who, if you're going to be trying to leave money to an heir and a potential heir, and that person has a lot of debt, you might want to consider using a spendthrift trust, because it will prevent the creditors from being able to attach and make sure that that money actually does flow to them.
Okay. So we've talked about wills, trusts. Talk to us about at what point in time the estate comes into play. And before I have you answer that question, just let our listeners know that when we're talking about wills, trusts, and estates, these are state-specific rules
Yes,
and
they are.
laws, right?
100%.
So you having been in Florida and have a trust created in Florida could be different if you pass away in the state of Indiana because you're not a resident of Indiana. Is that
So
accurate?
the rules are different per state, and so typically things are enforceable depending on where they passed away or where they formed the documentation. Usually, there's language that's included in documentation that says that it's enforceable in other states, but it would all. My recommendation is always to have your estate plan drafted in the state that you reside in.
Yep.
I think it's simpler that way. I think it removes questions.
Would you recommend if you move states then after your trust is established is to get that trust updated?
At the very least, what I would do is take that to an estate attorney in that state and have them review it and see what changes they would recommend, because those laws are different per state, but they might come back and say, hey, this is enforceable the way that it's written. We're just going to leave it as is.
So in the state of Indiana, and I don't know if you can speak to this live on air or not, there's a dollar amount in which an estate becomes mandatory, right? You have to have an estate. If your net asset value is over a certain dollar amount, you are required to have an estate drafted. If not, there's something they can do with like small estate affidavit. Is that correct? Can you speak to that?
It's not 100% right, but it's close. So that small estate affidavit, I don't remember the exact number, but I think it's around 60,000 right now. So if your estate is under 60,000, that's all of your net assets is under 60,000.
Home equity,
all of it,
everything,
everything.
money.
If it's all under 60,000, then theoretically if after you pass away, you would not need to open an estate and go through the probate process. You can use something called a small estate affidavit. And it wouldn't be you, it would be your heirs would be using a small estate affidavit, and they would just be saying, hey, look, these are the resources that are available to you, and we don't need to open this big estate because there's a small amount that is
needs to be figured out.
out. Over the 60,000, you would have to go through the probate process, whether you have a will or not. You have to go through what's called probate, and
Unless you have a trust set up.
unless you have, so unless you have a trust.
Yes,
And
okay.
so that's that small estate affidavit again, right? So the probatable assets need to be under 60,000. So if all your assets are in a trust, then theoretically there's nothing for the estate to handle, so you don't need to open anything. If it's over that threshold, and again, I think it's 60,000, but I'd have to check to be sure. If it's over that amount, then if there's a disposition of those assets, then you would want to open. Your heirs would want to open an estate to figure out what that process looks like and where everything is supposed to go.
I have a question. So what if an individual has absolutely zero finances, money, but they have jewelry, they have items that went from generation to generation. Do you suggest someone doing a will or actually having an estate because those things are still tangible? Does that make sense? Especially for community, like for myself. I have 4 kids. I ain't got nothing in the bank, but I do have like jewelry from grandmother, pot, stuff that's sentimental that you want to pass on. What is your suggestion?
Yeah, so there's 2 different ways to handle something like that. The first one is if you have specific gifts that you want to give to specific people, do it while you're alive.
Is that done through the will? Is that the best way for
Not if you're doing it alive. If you're doing it while you're alive, then the will doesn't control, because the asset you're talking about is no longer yours, so it's not probatable because you gave it away while you're living.
Okay, I was thinking you designated this to go to them after you pass.
Now, but that's the simplest way to do it, because then it doesn't go through the probate process whatsoever, and everything it's just done, right? If you wait until you pass away, then what I would use is a last will and testament that has documentation in it specifically talking about bequeathments or specific bequests, and there's an addendum that you can use that specifically says, hey, these are the things I want my jewelry to go to my daughter. I want my car collection to go to my son, and so you can actually specify. And if you draft it correctly, you don't have to complete that list right away. You can continue to work on that list even after your estate plan is already drafted. So if you get something further along the line, you don't have to pay an attorney to rewrite the list every single time.
Okay, so in your opinion, who do you suggest should get or seek out an estate planner? We've talked on set about our investments and who to talk to, and I know that during my research, just drafting on the low end could cost up to $300, but up to $1,200. Mm-hmm. So listening to the individuals in our community, who do you suggest? What kind of individuals do you suggest should seek out an estate attorney or planner?
Yeah, so I would say almost everyone. And the reason I say that is because if you know what the intestate rules are and you don't have anything, and you're okay with what the intestate rules say for what little you have, or you have absolutely nothing, then I would consider just doing that. But if you can manage to, if you don't know what the rules are, or if you have even tens of thousands of dollars, I would consider doing that. And there's another couple of reasons why. So the first one is those estate planning documents often come with documents that are to be used while you're alive as well. So they often include power of attorney documents, or healthcare representative documents, or advance directives.
Okay.
And those 3 documents are often included in the estate planning process. They can be used to help designate who will help make decisions for you while you're incapacitated. And it will also allow you to designate what your wishes are if you get into a medical situation where you can't make decisions by yourself.
Like a DNR?
Like a DNR, exactly. So those 3 documents can be very helpful even while you're still alive. So even if you are like, you know what, I don't really have anything, I don't want to make a will, it's okay to go, and you should probably go talk to an estate attorney anyway to get those documents, because while you're alive, it's not just about your finances, it's also about the medical decisions.
Is there typically a fee involved with like a consultation with somebody like yourself?
It depends on the attorney. My office does not charge for estate planning consultations. Some attorneys do. And I do know Write a Will Week is coming. It's in the next couple of weeks. And we're doing 3 days where anyone can come into any of the locations that we're going to be at and get an estate plan for free.
Oh, awesome.
There's one caveat. The one caveat is that they have to leave some amount of money to charity. And it can be a residuary clause, which means if all the other gifts fail, we want it to go here. That's all you need. And if you come in
in the
will itself, if you have a clause in the will that says you're leaving money to charity, then the estate, the will, the power of attorney, all those documents take.
When you say charity, does it have to be a
501c3?
501, so it could be a church or something like that?
That's
okay,
right.
awesome.
Yeah, it could be a church, it could be a nonprofit. Yeah.
So to clarify for our listeners out there, if you are looking to get something done or speak with somebody like Kyle, he does have these sessions coming up here that if you are willing to leave, a certain portion of whatever funds that you have at the end in your will to a charity, church, something like that, you will do the consultation for free.
Not just the consultation, we'll draft the documents.
Okay.
Yeah, we will execute it.
You want to tell our listeners how they can find you or what locations?
Yeah, absolutely. So you can contact my office. It's Kyle Gough Law. Our phone number 260-414-4878. And we're going to be at Electric Works. We're going to be at the Macmillan Health, and then I don't remember the third location. But give us a call,
and then you can direct them on what days and what locations that they can attend.
Yeah. So there's going to be 3 this year. We did 1 last year, and so we decided to up the ante, and so we're going to do 3.
That's awesome.
I don't remember exactly how many slots we have, but I know that there's some open. So if you want an estate plan, that's absolutely free. We can help you take care of that.
Awesome.
Great. And running out of time here, gentlemen, do you have anything you want to add or questions for Kyle?
Real quick, what's the best thing to do for, mom passes away, dad's still alive? What do they need to do there? Because a lot of times I have clients that one spouse dies and the other spouse has no clue what they should do next.
Yeah, talk to an attorney right away, especially if they are elderly, or if they have any anticipation of needing Medicaid or long-term care assistance, or even in-home services. Those are all things that you need to talk to an attorney right away to start planning, because you can save a lot of money if you plan correctly.
Okay,
awesome.
Good. Thank you. So, once again, we talked a little bit about the importance of having a will, what a trust is, the estate, when that comes into play for you. So, and I can speak from experience on the banking side. Start with adding beneficiaries to your bank accounts, to your investments, things like that. That those are assets that if somebody passes away, you don't need to wait for a death certificate. Well, I take that back. You do need to wait for a death certificate, but you don't have to go through the estate process and probate that's going to cost money and take time. With that death certificate, it'll allow you to access those funds and be distributed to whoever the heirs are. I always thought one of the saddest things, being in the banking role, was sitting across from an heir whose parents, or somebody passed away, especially unexpectedly, and unfortunately they didn't plan for that day. And they're in a tight financial situation, and unfortunately the heirs have to now deal with the financial side of things. That doesn't wait. Right, the financial side, bills don't stop, things don't, just because somebody passed away. They have to deal with this in a time that they should be grieving, right? So they don't really have time to do the grieving process, because they're having to deal with banks and financial institutions, all the stuff that had the person that passed away actually planned appropriately. It's going to make things a lot easier on their heirs, right, at the end of the day, right?
Right, exactly right.
Yep.
And if I may add one more thing, I know we're running out of time here, but I just wanted to add that the information I provided today is for general informational purposes only. I have to say that as an attorney. So if you want specific legal advice, please talk to an attorney. You can come talk to me, but please don't rely specifically on the information that I've said today for your own specific purposes. Instead, come talk to me, and we'll talk about your specific scenario, or talk to an attorney and get that going for you.
Great. Thank you. Thank you, Kyle, for being here today. Thank you to our listeners for joining us. This is, once again, information that, not a lot of us want to have this conversation, but it's a very important one to have.
Very important.
To instill the financial stability of our family when we're gone.
That's right.
Yeah.
So I wanted to leave before we close out. A lot of times we talk about the choices. Your life is a result of the choices you make. If you don't like your life, it's time to start making better choices. So we're fortunate to have you here and to have this information. And the gentleman from DR Financial, this is always just informational for our viewers, so we appreciate it.
Thank you. Thank you. Thank you for adding that, Millie. So to our listeners out there, thank you for joining us again today. Join us next week, 8:30, for our new podcast, Ice Cold. Wednesday, 8:30. We'll be doing the financial podcast every other week from the Ice Cold podcast. So join in. It's going to be some great topics that we're going to talk about. So till then, our Neutral Voices. Peace.
Have a good day.
Happy trade.
Appreciate it. Thank you.
Happy trade.